Now we'll discuss section 12, which provides the legal effects of adoption, and it lays down the circumstances and consequences of the adoption as under an adopted child shall be deemed to be the child of his or her adoptive father or mother for all purposes with effect from the date of the adoption, and from such date all the ties of the child in the family of his or her birth shall be deemed to be severed and replaced by those created by the adoption in the adoptive family, provided that the child cannot marry any person who he or she could not have married if he or she had continued in the family of his or her birth. Secondly, any property vested in the adopted child before the adoption shall continue to vest in such person subject to the obligations, if any, attaching the ownership of such property, including the obligation to maintain relatives in the family of his or her birth. And thirdly, the adopted child shall not divest any person of any estate which vested in him or her before the adoption. And now we'll discuss the very doctrine of relation back. And this placed the adopted son back from the date of the death of the husband of the adoptive widow or mother in the adoptive family, so as to create all the rights and privileges in his or her retrospectively as a preferential heir. He could divest his mother of the property inherited by her from her deceased husband. Now, under the very act, the adopted child is deemed to have come into existence in the adoptive family from the date of his actual adoption and not from a back date. So, in regards to that, we would like to discuss an important leading case, that is Punita Vahali versus Ramalingam in 1970. The Supreme Court held that Hindu widow has absolute owner of the inherited property from her husband, and the adopted son could not divest her from the property even if she gifted to her daughter. And in another important leading case, that is Dinaji versus Dadiji in 1990, the Supreme Court held that adopted son cannot divest any person of any property which had vested in him before he was taken into adoption. The most important aspect of this section is that the adopted child could not marry any one from the family he or she was taken in adoption, and also in the family to which he or she was adopted. The principles of Sapinda and the degree of prohibited relationship governs this section. So, this is as provided under Section 12 of the present Act, that is Hindu Adoption and Maintenance Act 1956, but we'll discuss certain provisions of the old law, and that is regarding age of adoption. So, in Dattaka Mimamsa, the very provision was that adoption must be below 5 years of age, and regarding Dattaka Chandrika, the adopted child should be unmarried and there should not be any Upanayana ceremony, and this sort of adoption was prevailing in Bihar, Banaras, and Odisha. And regarding Bombay, the very age of adoption was under the old text of any age a child could be adopted. And regarding Madras, the very adoption of the child could be even after Upanayana ceremony. And regarding Punjab, among the Agrawal and Jain Vaishya, even a married child could be taken into adoption. And regarding the old sources regarding adoption of a child, as it was provided, the very child taken into adoption must be Hindu, must be a male, and must be under nearest Sapinda and same caste, and must not be a orphan or a deep and dumb, and only a son could be taken into adoption. And those sources which provides these provisions under the old law, those Hindu old texts such as Dattaka Mimamsa, Dattaka Chandrika, then Smrutis of Vasishta and the Mitakhara. So these are the old sources which provides that the very age and the conditions of caste, Sapinda, etc. And as we found under the old Hindu texts, but by adopting the very Act, Hindu Adoption and Maintenance Act in 1956, the Parliament made a revolutionary change in the old text relating to adoption, and it gave the very question of adoption into a secular form, and in that secular characteristic now both the male child and the female child could be taken into adoption. So also a female, that is the wife, is given the very right to take adoption, but regarding the very age gap in taking adoption for both the male and the female, while taking adoption by a male of a female, then there must be 21 years of age gap in between the male and the adopted female. And in the same way, whenever a female, a wife, taking adoption of a male child, there must be 21 years age gap in between that female and the male child that would be taken into adoption. So also now the very consent of the wife is very important and a mandatory provision. So besides consent, also there are certain revolutionary changes brought under the act, and that was regarding the very restriction relating to Shapinda or relating to the very degrees of prohibited relationship, which restrictions we found under the Act, so also on the decisions of the Supreme Court and the various high courts that regarding adopting a child, there must be such restriction relating to Shapinda and prohibited degree of relationship between the child to be adopted and the male or female taking into adoption. So, these are the revolutionary changes which were brought under the Act, made it secular in character.